Let's talk about an extremely important case governing discovery in civil procedure, specifically attorney's work product. So that case is Hickman versus Taylor from 1947. It was a unanimous decision written by Justice Frank Murphy. There's a concurrence by Justice Jackson. And basically what happened in that case was you had this tugboat, J.M. Taylor, and it tragically sank. There was loss of life upon it. And basically they had to prepare for lawsuits. So the tugboat's owner's lawyer, Mr. Fortenbaugh, interviewed witnesses to the incident to prepare for the owners being sued. When the plaintiffs sued the owners, they wanted to discover Mr. Fortenbaugh's notes of the interviews. Fortenbaugh objected, but then at the trial court level, they overruled his objections. So what had happened was the petitioners had filed 39 interrogatories to the tug owners, with the 38th interrogatory seeking to get exact copies of statements about the sinking of the tug, or if they were oral, to set forth in detail the exact provisions of the statements or reports. The tugboat owners answered all interrogatories except for that 38th one that they objected to. They said that while statements of supervisors had been taken, they were privileged matters in preparation for litigation, and therefore you cannot obtain them. And basically the district court said, yeah, no, they're not privileged. Sorry, you have to comply with this interrogatory. They required Fortenbaugh and the plaintiffs to answer the 38th interrogatory. They refused, and they were adjudged in contempt and ordered to be imprisoned until they complied. So the Third Circuit Court of Appeals reversed. They held that the information was part of the work product of the lawyer, and therefore it was privileged from discovery under the federal rules of civil procedure. The Supreme Court granted certiorari. And so what Justice Murphy ends up writing is that the work that the lawyer, Mr. Fortenbaugh, here did is protected under the rules of discovery. Even the most broad theory of discovery cannot possibly justify unwarranted inquiries into the files and mental impressions of a practicing attorney in a case. Forcing an attorney, he says, to repeat or write out all that certain witnesses have told him and to deliver this to his adversary gives rise to dangers of inaccuracy and downright untrustworthiness. There's no legitimate purpose to this, the court holds. The petitioner admits that he wants the oral statements only to help him prepare to examine witnesses and to make sure that he didn't overlook anything, but Murphy says this is just not sufficient. It's not sufficient to allow him an exception to the privacy of Attorney Fortenbaugh's professional activities. There could be a rare situation, he says, which would justify production of these matters, but this ain't it, Chief. This does not justify turning over the impressions of Attorney Fortenbaugh. So the appeals court judgment is affirmed. The lower court messed up. Justice Robert Jackson concurs here, and it's not a concurrence saying, oh, I disagree with you on this or that. It's a concurrence just saying, I'd like to add something here. He says, it seems the real purpose and probable effect of what the petitioner was calling for was to put trials on an even lower level than a battle of wits. It is very demoralizing to have a lawyer write out and deliver to the adversary his account of a verbal exchange with a witness. There would almost inevitably be some inaccuracies, and opposing counsel could just pull out the written statement and constantly accuse the lawyer of contradicting himself, badgering the lawyer with purportedly inconsistent statements. It would force the lawyer to be a witness in self-defense. That is a really good point, and that is a really good policy insight into how these things could work out. You always have to be thinking about how some of these procedure things can affect the substantive rights of parties in court, and how this type of thing, it would be a policy disaster if we get to allow these people to have their way and just bring in these written statements, bring in all these past impressions, and it would lead to some absurd results. So this is an important case you're going to need to know. There's probably going to be some sort of issue spotter relating to it or some sort of question relating to it. If you're in a law school class on civil procedure, if you're an attorney and you want to learn more, I'm glad that you showed up to this video. I love doing videos on the law. Please like, comment, or subscribe to the channel. Thank you so much for watching. This has been the more is the merrier. I hope that you can take this video to the bank, get a straight A+, like, comment, or subscribe, and I will speak to you in the next video.